Okay, thank you for joining our training today on small claims court. We appreciate you being here. I am, just so you know, recording this presentation, so just for future use, so we can show it to clients if they want to review it. So if you have any questions, feel free to ask. If you're not comfortable asking because you want it to be confidential and private, that's fine. You can wait till the end, or you can email me later. So let's go ahead and get started. I have a PowerPoint. I will share my screen and then we'll go ahead. Okay, can you see the PowerPoint?
Yes.
All right, thank you. Okay. So this is a brief workshop on small claims court. We probably won't cover everything, but it should give you a good general idea of how it works and things to know. And if there's anything I don't cover that you have questions about, feel free to ask or again, email me later, and I will do my best to answer those questions. So the first thing we're going to talk about is what is small claims court. It's a special court designed to resolve cases in a quick, fair, and inexpensive manner. You may ask a lawyer for advice regarding your case and even help with preparation, but no parties can be represented by a lawyer in the courtroom. Hearings are informal, and the rules are relaxed. The benefits of going to small claims court are, again, because it's inexpensive, and even more so, I think, because it's quick. If you, as many people know, try to sue somebody in actual civil court and civil litigation, you can be waiting years before you ever get a resolution to your case. Small claims court is meant to go much quicker. And I think that's the biggest advantage. Of course, the drawback is the limitation, monetary, but we'll talk about more about that later. So the first thing you need to do if you would like to sue somebody in small claims court is filing your case. So you can do that by using California Judicial Council Court Form SC 100. That's available online. All you need to do is Google it. You can also, if you don't have access to Google or a printer, you can go to the courthouse and they can provide that form for you. So what is a claim? A claim is the document that will start the small claims case. It tells the court who you are suing. It tells the court why you are suing that person, and then it tells the court what you're asking for. So before you file your claim or to prepare your claim to file it, this is the information that you'll need to know to be able to do that. Are you the plaintiff or the defendant? Obviously, I know this is pretty basic stuff for people who are lawyers, but if you're not a lawyer, the plaintiff is the person that is suing the other person, and the defendant is the person that is being sued. So, for instance, if you're suing your landlord, you are the plaintiff and the landlord is the defendant. Do you know where to file your claim? So you need to file your claim in the right courthouse. Depending on where you live, I think some counties there may only be one courthouse, but in counties with multiple courthouses, you need to file the case either in the courthouse closest to where whatever the incident or the actions that give rise to the claim took place, or closest to where the defendant resides or runs their business. So before you can file a claim in small claims court, this is a big one. This is something we do a lot of at HERA. You actually have to actually ask the defendant for the money or property that you're going to be suing them for. So before you file your claim, usually the way most people do that is by sending a demand letter saying, if it's your landlord, you owe me this much money. This is the law. This is why I think you owe me that money, and I'm demanding that you pay me that money. If they don't respond or they refuse to give into your demand, then you can take them to small claims court. You need to know the reason you're suing the other party. You should know whether the defendant is an individual doing business as something else, another name, a corporation, or a government agency. Oftentimes, if you're suing your landlord, it's going to be an individual, but could also be a corporation or an individual doing business as. So that's something you'll want to decipher. Normally, a good place to look for that would be your lease agreement, which should tell you who the other party to the lease is. It's normally who you're going to be suing. And then if the defendant is a business or a government agency, you should know who the agents for service of process is. What that means is that government agency or businesses have somebody designated to accept service for them. So if you sue them, you can serve the complaint on that person, and that counts as the business acknowledges that counts as good service, and it's that person's job to inform whoever they need to inform that they've received these documents. And that goes the same for government agency. So the monetary limits. This is one of the biggest drawbacks, or the biggest drawback probably of small claims court, is that you cannot sue somebody in small claims court in California for more than $10,000. Not always a big deal, because a lot of times, landlord tenant disputes, which is what we do a lot of at HERA. Oftentimes the amount in controversy is not over $10,000, so that's not a big deal. But you do need to know if you're expecting a higher payout than that, or you think you're entitled to a higher payout than that, then small claims court is probably not for you. But anything less than that, if you don't think you're entitled to more than that, small claims court really is a good option. It prevents the landlords from showing up with lawyers, which is a big thing. Oftentimes the tenant won't be able to afford representation, which isn't usually the case with landlords. So it kind of levels the playing field. So you are limited, though, to filing 2 claims for more than $2,500 anywhere in the state of California during 1 calendar year. So if you're suing somebody for over $2,500 on small claims court, you can only do that twice in 1 year in this state. You can file an unlimited number of claims for $2,500 or less. And the other thing that's very important right now, especially for the work that we do at HERA, none of those limits, including the $10,000 limit, apply if the dispute is related to COVID-19 rental debt. So when you want to sue somebody in small claims court, you file your claim, you start the case. The next thing you need to do is serve the defendant with the documents. So service the rules are pretty finicky. You need to complete service correctly, or it's going to cause delays. So it's very, very important that you get this taken care of the right way. So there's a couple different types of service. There's personal service and there's substituted service. Also, if you have a defendant who's out of state, you're going to want to consult with an attorney regarding the special requirements for serving that defendant to make sure that service is proper. So personal service, that's when the defendant is actually handed the documents directly. That is good service. If you find the defendant, and well, not you, but the person serving the documents finds the defendant and hands them the documents in person, service is completed. And that's all. You don't need to do anything else, as long as you complete it 15 days before the hearing, if that person was in the same county as the court, or 20 days before the hearing if the person is in California but in a different county than the court. And that's if they are in the county at the time of service. Substituted service is a little more tricky, but definitely accomplishable. When you can't complete personal service, the backup method is serving the party through what's called substituted service. That's when you leave a copy of the complaint at their residence or their normal place of business, and then later you mail them a copy of the complaint to the same address where you served it. So it's important that when you do that, though, if you leave it at their home, it needs to be with an adult. You can't leave it with a child. If you leave it at their usual place of business, it needs to be with the person who's in charge. Either way, documents must be in an envelope bearing the defendant's name, and the person serving them must state they are for a legal case. After that, the person who served the documents must mail them to the exact same address where they left them. And it must be by first class mail, postage prepaid. No other type of mailing would be acceptable. And the timelines are a little bit different for substituted service. For somebody in county, the same county as the court, it has to be at least 25 days before the hearing. And for somebody out of county but in state, it needs to be at least 30 days before the hearing. So who can serve the documents? Really anybody except for you. So marshal, sheriff, constable, it is an option. You can contact your sheriff's office and see if that's a service that they'll provide. You can contact a private process server to see if they'll serve it for you. Of course, that's going to cost you money. You can also have any person over the age of 18 that's not a party to the case serve the documents. But ultimately, no matter who serves the documents for you, it's your responsibility as the plaintiff to ensure that you get the proof of service and you file it with the court prior to the scheduled court date. Proof of service, for those that don't know, is a document signed under penalty of perjury that basically says, I took these documents and I served them on this person at this date and time by this method. And then you file that with the court so that the court knows and has proof that you actually served the document. So again, whoever serves the documents, it's your responsibility to take that proof of service and go file it with the court before the hearing. Temporary judges. So small claims court often uses temporary judges, not all the time, but most of the time. They are attorneys practicing, they're attorneys with at least 5 years of experience practicing law. You do have the right to ask for a judge or a commissioner and not have a temporary judge hear your case. It's not always necessary. Usually the temporary judges are sufficient, but if you don't feel comfortable with that, you can tell the court, you're not agreeing to that. You would like a real judge or a commissioner to hear your case. Just keep in mind that if you want a judge or a commissioner to hear your case and not the temporary judge, you should let the court know as soon as possible. If you wait until your court date to request that and they don't have a judge available that morning or that afternoon, which is likely, they're going to have to reschedule your court date, which is going to cause further delay. So whatever time you decide, you don't want your case to be heard by a temporary judge, it's best to let the court know that at that time. So what to expect when you go to court. Children will not be allowed in the courtroom. Some courthouses have daycare rooms, but the requirements are pretty strict. So try to, I recommend that, if you have kids, that you try to arrange childcare for that day. And also, you don't need, you're probably going to be pretty stressed out as it is. So, putting any extra obligations onto yourself for that time will probably just stress you out more. So if you can find childcare, that's a good idea. Arrive organized and prepared. Don't be late. If you're late, they can hear the case without you, which isn't going to be good, obviously. So make sure you're on time. Have at least 3 copies of each document or photo you want to submit as evidence. And realize that, any documents or photos you submit as evidence may not be returned to you in the future. The judge may take them with him if he or she takes the case under submission, and then they may not be returned to you. So be prepared to lose those if possibly. Also, bring your witnesses if you have any with you to court. Have them on time as well. The court will ask you before the hearing starts to go in the hallway with the other party to exchange and review any documents or photos you plan on submitting as evidence, and anything that they plan on submitting as well. I think this could be a difficult part for a lot of people in small claims court, particularly if it's somewhat of an emotionally charged situation. But remember that you're in a courthouse. The judge is going to make the decision today. So while you're out in the hallway talking to that person, keep it professional, stay calm. Just do what you got to do, and then be prepared to get back into the courtroom and present your case. So also, when you're dealing with civil litigation, the plaintiff will present their case first, and then the defense will present their defense to the judge. If the other party doesn't show up, still be prepared to prove your case. In small claims, you won't just win just because they didn't show up. So still have your evidence ready to go. Be ready to make your case to the judge. So preparing for the hearing. I think number one, understand the law you were suing under. If you think your landlord or somebody else has violated a particular law, a particular statute, make sure you know what the law is, so that you know what you need to prove to the judge, and what you need to demonstrate to the judge to show that that person, the defendant, actually violated the law. So one of the things you need to prove, let's say you're trying to sue your landlord because they didn't fix habitability issues on time. So you would need to prove that you reported these issues, that the health inspector or code enforcement came out and inspected. You would need to prove that they issued a citation, and you would need to prove that 35 days has gone by and that hasn't been repaired. And then you would need to prove that the condition was not caused by you. So be prepared to prove all of those things when you walk in there. And that's really step number one you want to take when preparing, because the next step is gather your evidence. And the way you're going to know what evidence you need to gather is by knowing what you need to prove. So also, when you get in there, have all your documents and photos in order when you get to the court that day, so that you look prepared, you look professional. Everything will be easier to follow for the court if you do that, and it will make you more persuasive. Also, in preparation, consider whether or not you need witnesses to prove your case. Oftentimes in small claims, you don't. We'll talk more about that in a minute. But you may sometimes need a witness or two. So consider that when you're preparing. And then prepare an opening statement, your testimony, and your argument for the end. Okay, courtroom conduct. Dress professionally. Always dress professionally. Remember, it's a court. I know not everybody has a suit, but I think it's good to wear the nicest clothes you can, just to show respect to the court, and just it's best practice. Wait in the gallery until the judge calls your case when you arrive. Always address the judge as your honor. Always talk to the judge, not the other party. This is a really important one that I think gets lost on a lot of people. When you're making an argument, you're making a request, anything, remember you're directing your comments, you're directing what you're saying to the court, to the judge. Don't be looking over across the table to the defendant, or be the defendant. Don't look over to the plaintiff and talk to them directly. You talk to the judge. If the judge needs a response, he'll ask the other party for a response. And this is, if you stick to this, it's also a good way to make sure that you're staying professional, and it'll help you out a lot in the long run. And then remember to remain calm. If you get angry in there in court, it's not only unprofessional, but it's less persuasive. If you're calm and you know the facts of your case and you're confident that you're right, well, that's going to be a lot more persuasive than if you go in there and you're yelling and you're pounding the table. That just doesn't work. That stuff is for TV. It doesn't work in a real courtroom. And remember, don't insult or disparage the other party. Stick to the facts. You don't need to be in there making negative comments like, oh, this person's an idiot or this or that. Just say what they did, what they didn't do, why that's a problem. But you don't need to actually bring in personal insults or attacks. So witnesses, as I said, we would cover a little bit more. So in most small claims cases, the plaintiff and the defendant can provide sufficient information for the judge to understand the claim and make a decision. However, sometimes that's not going to be the case. So if you feel like witnesses are necessary, line your witnesses up well beforehand. Let them know the court date. Make sure that you prepare them before they testify. I mean, you can't tell them what to say, obviously, and you can't tell them what to lie. Tell them to lie, obviously. But you definitely want to review the facts. You want to review their testimony. Ask them what is their version of events. Last thing you want to do is, you think a witness is good for you. You haven't talked to them, no, you haven't reviewed the facts, and you get into the courtroom and they're actually bad for you. And they're saying the things you didn't want them to say. So make sure you get that squared away well before the court date. Try to have your witnesses present in person. Some courts will allow telephone testimony, but that's not a guarantee. So having them there in person is the best practice. If that's not possible, you can have your witness submit a signed declaration under penalty of perjury. But this is also not best practice either, because technically it's hearsay. Not some judges will accept it, some judges won't. A lot of times they'll just say that they'll give it the weight it deserves, which you never know what that means, if they're giving it a lot of weight or no weight. So definitely best practice is have your witness there in person if you can. If a witness will not attend voluntarily, you can ask the clerk of court to issue a subpoena for their attendance. If you do that, you will be responsible for serving the subpoena. But keep in mind that, somebody who comes to court under, coercion, basically being forced by a subpoena to be there, it's probably not going to be the best witness for you. If they didn't want to be there in the first place and they're not too happy about being there, there's a good chance their testimony is not going to be that helpful for your case. Just something to keep in mind. So presenting your case in small claims court, it's best to start with a straightforward statement. What you're asking, start with what you're asking for and why you're asking for it. For an example, Your Honor, I'm suing the defendant for $5,000 because I paid him to build a deck and he never did it. So right there, the judge knows, okay, this is the issue. This is what I'm looking for. Did this person prove their claim? If you jump right into the story, the judge isn't going to know what to listen for until you tell them at some point in your story or at the end what you're asking for and why. So it's always good to set that out there right at the beginning to kind of set the judge's radar. And then the next thing you want to do after you let the judge know what you're doing, what you're suing for and why you're suing, is present your documents, your photos to the judge. Make sure it's organized and straightforward. So the reason I said before you need to have 3 copies is because you're going to want one for yourself. You need to refer to it. The other party is going to be entitled to anything you submit to the court, so you need a copy for them, and then you need to give a copy to the judge. So at least 3 copies of every document and every photo. Once you've given that stuff to the judge, then you can start your story behind your claim. And that should give the judge some clarity about the documents and photos you've given them. And then we'll start to understand, okay, this is the documentary evidence we have. This is the story that kind of pieces those documents together. And then finish after doing that, just by summarizing the facts and explaining why those facts demonstrate that the defendant violated the law, and explain why the violation of law entitles you to the amount of money that you are requesting. That part is really important, I think. You don't want to just go into court and say, this guy did this, so I want $10,000, because that's the most amount of money you could ask for. Whatever amount of money you're asking for, make sure that you can actually explain to the court how you got to that number. How did you calculate that? I got to $10,000 because he owes me, rent for 4 months and my rent's $2,500. Or something of that nature, so that it doesn't just seem like a money grab. You can include other things in there too, but if you're saying other types of damages, fine, other harm that you suffered because of that person's actions, but just make sure that you can explain how you got to that number, and it's not just an arbitrary number. So that concludes the presentation today. I see these are a couple other websites you can refer to if you want more help with small claims court, more advice. I'd be happy to send the slides out to anybody as well if they want. Feel free to contact me. I see there's a couple questions in the chat, so give me 1 second. I'm going to look at those. So can the plaintiff serve, or must it be a non-party person over 18? It must be a non-party person over 18. But when it comes to the subpoena that we talked about, if you want to subpoena a witness, that doesn't apply. You're actually allowed to serve the subpoena yourself. You don't have to find somebody else to do that. Will I be sharing the recording after? Yes, I don't know how to do that, to be honest. But what we do is save the recording, and then we post it on our YouTube channel. And I could, once our admin does that, they're a lot smarter than me about that stuff, and I'll be more than happy to send you the link to YouTube. And then, will you be sharing the slides? Yes, I can. I'd be more than happy to email you the slides right now. If you want, you don't have to put your email in there. I can give you mine, and you can email me. Or I can just type it in the chat and let me know if you can see this. And then you can email me there and just say, hi, Dan, this is so-and-so from the training, from the workshop. I would like a copy of the small claims court slides, and I will send them to you. So can you see that in the chat?
No.
Okay, let me see. Let me answer that question. Can you see that one? I answered a question directly, which is a little different than the chat, I guess.
Yes.
Okay, so send me an email there. I'll send you the slides. I see this other question. Is COVID rental debt only defined as rent owed from March of 2020 to September of 2021? And will other debt related to the eviction moratorium be litigated in small claims regardless of the amount? That's a tough question. I don't know exactly what they define as rental debt. I mean, I would assume it's probably the amount of the time that the moratorium was in place. I don't have a definite answer on that. As far as will other debt related to the eviction moratorium be litigated in small claims, regardless of the amount? Not necessarily, because what we're seeing a lot of is, like evictions cases with back rent. And those are filed in civil court, not if it's an unlawful detainer and they're also asking for rent. Those are generally filed in civil court. You can't. So if it's part of that, part of an unlawful detainer, then no, it won't be handled in small claims court. But yeah, if the landlord, for maybe you've already moved out, maybe they're not asking you to move out, but they want to sue you for the damages, which is probably an odd situation. But that, regardless of the amount, they can file that in small claims court. Does that answer the question? Half of it, at least. All right. Any other questions then? All right. Well, I appreciate you attending. I hope this was helpful. And again, send me an email. I will send you the slides, and then later on, once we get this uploaded to YouTube, I can send you a link to, or you can look on HERA's YouTube account. There's a lot of other videos on there too that you may find helpful. So thank you. I'm going to end the presentation now.